Thank you so much again, guys, for coming to our webinar. So today we're going to be going through how to terminate employment legally in Australia, a practical playbook for Australian SMEs. My name is Patrick Deme. I'm the Australian HR business partner for MyHR Australia. Obviously, we do have our New Zealand side of the business as well and our Canadian side. So who is MyHR? So MyHR is an outsourced HR, right, covering all employment matters. So we combine our expert HR support with smart HR software, and that's really what we're good at. We support over 1,400 employers over Australia and New Zealand, of course, and our clients range from anywhere from 1 to 1,000 staff across every single industry and every region. The main thing here as well for us is that we're cost effective and no lock-in contracts. So now with that, guys, a bit of housekeeping before we begin. So questions are always welcome. Drop them in the chat as we go. The recording and slides go out after the session. So if we have missed anything, please feel free to watch the session afterwards. Another one on this is general guidance, right? Obviously, I don't have your circumstances on me. And for that reason, obviously, this is not legal advice on your situation. So what I'd love for you guys to do is tell us in the chat which termination is on your desk right now, if any, or for instance, you might have another issue with it. So here's the agenda. We're going to go through where the risk actually sits. Unfair dismissal, general protections, summary dismissal and underpayment, redundancy, including industry-specific schemes, and this will be very important for your tradespeople, and then paying entitlements and when. Okay, so let's start where the risk actually sits. So two claim types do the most damage, and both are getting a lot more common. Some of you may have even seen some of these. So the claims picture. So Fair Work Commission lodgements keep climbing. I don't know if you've seen my last webinar, but AI claims are sort of muddying everything up in the sense where Fair Work has claims going all the way until 2028, right? It's getting to that point. So 44,075 applications were lodged in 2024 to 2025, right? Now, that's 24% above the 5-year average. Unfair dismissal, generally speaking, was the biggest single category at about 16,500. There's a lot less of general protection dismissal claims, right? 6,209 general protections dismissal claims. So that's up 13% on the prior year and 27% above the 5-year average. Now, it was up another 57% in the first quarter of 2025 to 2026. And I think you guys might be able to guess why. AI, right? So AI claims have actually meant that a lot of these general protections claims are being made by, I guess, ChatGPT, Claude, etc. And unfortunately, regardless of who made them, it still creates a claim. Now, most of the applicants cannot even claim unfair dismissal, right? Around 2/3 do not actually meet the minimum employment period, right? And we're going to go through what that actually means. A lot of people do sort of muddy that up with probation, but I will explain that. Now, the Commission tightened its process, right, in November 2025, and again from the 7th of July 2026, so very, very recent. If we're looking at unfair dismissal, right, was the dismissal harsh, unjust, or unreasonable, right? This is what we're looking at. So who can actually claim for unfair dismissal? Well, you're looking at, number one, the minimum employment period, right? So what is that? Well, it's the 6 months of continuous service, or 12 months if you're a small business, right, of continuous service with your business, right? And what that means essentially is it counts any paid leave, right? Unpaid leave does not count towards this, right? Does not count towards a continuous service. But for instance, any annual leave that they take, any paid sick leave that they take will actually count towards their continuous service. We also do count casuals if they are engaged regularly and and they are staff of associated entities. We can go through what that means as well. Now, another part of the eligibility is income and award average, right, and coverage. The award or agreement covered staff are protected in terms of whatever they earn, right, whether that be overtime, penalty rates, or allowances. Award-free staff only if under the high income threshold have the access to unfair dismissal here. Now, that threshold is $190,000 and 100 from the 1st of July 2026, and this does increase every single year, guys. So as time goes, the bar moves a little bit further, right? Now, they have 21 days to lodge an unfair dismissal claim if they do have the access, right? So this is really important to understand because a lot of employees will actually make these applications after the fact, right? Now, when that happens, guys, you can actually write to the Fair Work Ombudsman essentially to, well, not to throw it out per se, but to take that into account and maybe look at throwing it out. Late claims proceed only where exceptional circumstances are shown, right? And so what that means, guys, is that the issue here is that sometimes those applications might take even more than 21 days, right? An employee might take 30 days, might take 40 days, right? Depending on their circumstances, the commissioner may actually see them, right? And that's where we can't be, I guess, 100% on the fact that, oh, it's outside of 21 days. There's no way the commissioner will see this. Unfortunately, we do live in a bit of a world where the commissioner may see something that might look good on their resume, for instance, in terms of a matter that they'd like to go over, and they'll see it anyways. The main thing here, guys, is to remember that even if it is after 21 days, there is a possibility the commissioner might see it. So do not assume the risk has passed until that window has closed, and even sometimes in very exceptional circumstances, that window is a bit larger. And then finally, guys, we have the Small Business Dismissal Code, right? So now this applies only to your employers of fewer than 15, right? So the Small Business Fair Dismissal Code is not a sort of be-all end-all. If we follow this, nothing bad will happen, right? But it is a great guideline / checklist for you guys to work through and for you to sort of look at in terms of, okay, have I given them a fair chance to respond? Have I given them, for instance, have I documented X, and the other, right? Complete the checklist, right, at the time, right? Not once the claim actually lands. That's where people get in a bit of hot water. So following it properly makes the dismissal consistent with the code, right? And that's really what's important here. The main thing when it comes to a termination is two things have to hold up. So number one is a valid reason, of course, right? So it needs to sound defensible, connected to conduct or capacity, right? Backed by evidence that you can produce, not just general impressions, right? I guess the reason I'm talking about this, guys, is because what I say every single time to every client I have is documentation is king, right? Having the evidence that you can produce to say that, for instance, you didn't do something that an employee has said you did is really important, where we look at the fact that we have a reverse onus of proof, right? A lot of the time, guys, 9 times out of 10, it's going to be on us to prove we didn't do what the employee said, right? And that's the important part of why documentation is key. So it needs to be, of course, as well, serious enough to end the employment rather than warn, right? Now, this is after they've got an unfair dismissal access. For performance, they must have been warned and given a real chance to improve. As well as, another reason could be a reason you discover after dismissal, right? This actually wouldn't save it whatsoever, right? Now, when you're actually at a commission hearing, right, tribunal, whatever it may be, any reasons that you discover after the fact are not going to assist you within your actual claim, right? This is the issue, and this is why documentation prior to is key. So a fair process, that's the second one, right? So put the reason and the specific allegations in writing, right? Now, this is really, really important. It's also important that, for instance, where we have somebody who's sworn, who has said something pretty gross or something we don't really want to write, it's actually really important that we write these things. The reason and the specific allegations do need to be in writing. They need to be given a genuine opportunity to respond before they decide. They would obviously need to be offered a support person, right? And never unreasonably refuse one, right? Look, in all honesty, guys, when it comes to offering a support person, you don't actually have to offer one. So the Fair Work Act doesn't actually state that you need to offer a support person, rather that you need to not unreasonably deny one, right? That is the main thing there. once it comes to the next part, right, you're considering the response with an open mind, right? Then we're confirming in writing. What's really important here, guys, is that we never give an outcome in the same meeting, right? What this will do is simply just cause us, I guess, detriment, right? When we're looking at it, we don't want to show that there was a predetermined outcome in play, right? For that, we need to be able to deliberate on what those responses are, right? So let's say we've done the disciplinary, right? We might have an idea that this person's going to be terminated specifically due to their responses, right, during the meeting. Maybe they were absolutely terrible. They took no accountability whatsoever, and they might have sworn at you, etc. Now, those responses are going to affect what the outcome is going to be. But the main thing here, guys, is that you need to show that you've deliberated and taken that time to essentially make a fair decision, right? Generally speaking, that's 24 to 48 hours. One thing to also keep in mind, guys, is that your size and your HR resourcing are weighed, but they're not a defense, right? So your small businesses where you guys don't have HR, right? Look, unfortunately, that isn't a defense, right? Where you guys are above 15 employees, it's expected that you would have fair and formal processes in place, right? And the issue is that I know 15 isn't a lot of employees, and of course, that's still considered a large business. Well, once we're over that mark, right, we can no longer look at the Small Business Fair Dismissal Code. We're now looked at, by Fair Work as a large business, and we're expected to act as one, right? And that's what's really important there. Moving on to what it actually costs. So remedies, exposure, and the costs you don't see, right? So number one would probably be reinstatement. That's probably the primary remedy that I see. Compensation is generally the fallback. If compensation is capped at 26 weeks pay or $95,050, whichever is lower, right? Look, we generally won't see it actually at 26 weeks, right? A lot of the time, guys, the compensation might be a lot lower, might be around 4 to 5 weeks, right? And it may as well consist of the reinstatement. It does depend on what the commission chooses. Now, it does compensate lost earnings, so it drops for misconduct and other income. Now, reinstatement is not capped and can carry back pay to the dismissal date, right? So what's important to remember here, guys, is that if we have terminated someone and they do go through unfair dismissal, there is a possibility that if they are reinstated, we may have to back pay them all the way back to when we originally terminated them. So most matters generally do settle at conciliation, right? And what's important about that to understand is that, look, conciliation is before you get to the actual tribunal, right? Before you actually get to the Fair Work Commission. And in all honesty, guys, a lot of people like to settle at conciliation before a lot of this is tested, right? Where you move past conciliation, you're, I guess, risking the possibility of getting fines, for instance, for certain contraventions against the award, against the act, whatever it might be. So settling it at conciliation can be a very, very, less costly battle, I'd say. So the real cost, again, is management time, right? Legal spend and the hit to your team, right? So now when you get a claim, if you have gotten a claim, as some of you might know, it's very, very stressful, right? As we can imagine. You've got months and months and months of, waiting, for instance, sometimes, responses, this, that, the other, obviously all while you're running your business, right? So it's never a great thing to go through, as we can all imagine. So now moving on to the second type of claim that we're going to be speaking about today. This is, in all honesty, probably the worst of the two bugaboos, right? So now what we've got here is general protections, right? So now for this, there actually is no service requirement, right? There's no income cap and there is no compensation cap. And this is why it's scary. Adverse action covers dismissal, demotion, cutting hours, and changing duties, guys. So look, adverse action against a protected trait or against a protected right is what creates general protections risk, right? So we're going to go through that in a bit of detail, but this is why this is the harder claim to defend. So number one, it's unlawful where a substantial and operative reason is a workplace right, a protected attribute, or a union activity, right? So as an example, guys, some of the things that might be considered as a workplace right would be taking leave, asking about your pay, raising a grievance against another employee. All those are workplace rights, right? For instance, protected attributes would be whether or not they have a disability, whether they might be LGBTQ, the like, right? So now, where we take adverse action against these traits or rights, that's where the real risk comes in, for instance, right? As we said, these claims are uncapped, right? And the compensation, again, I've seen it go up as far as up to 399,000 as far as I've actually combed through, but that was a long time ago as well. So now, workplace rights include, like I said, making a complaint or inquiry about employment, and or taking or requesting an entitlement, right? So, like I said, guys, the onus reverses, right? Once the employee points to the right, you have to prove the real reason, right? So it's as simple as an employee saying, well, I was terminated, but I believe it was because I disclosed that I had dyslexia, right? Very soon after I disclosed that I had dyslexia, I was terminated. Now, that might not be the reason whatsoever, right? In our minds, the employee has put two and two together, and unfortunately, we might not have any documentation that proves otherwise. And this is where that risk lies. So the proof comes down to yourself, right? To your decision maker, actually on their mind. So no minimum service for this one. So where these claims come from. So the pressure points worth watching, right? So number one is that timing is not proof, but it is the first thing that anyone looks at. So dismissal soon after personal or carer's leave or a long illness, what does that look like, right? It looks like we've terminated them for their leave, right? If there's nothing else to sort of look at. What about after a complaint, right? Dismissal after a complaint about pay, safety, bullying, or for instance, a manager micromanaging them, right? This again is going to look like adverse action. Dismissal after a flexible work request or return from parental leave. Again, adverse action against what have we got here? A flexible work request, which is a right, and return to work from parental leave, again, another right. Dismissal after a workers' compensation claim is lodged, right? Now, guys, this is a bit of a double whammy because, of course, if we've terminated the employee, we all know that doesn't mean that their workers' compensation is going to stop just there. The employee can also raise a general protections claim, right, stating that they were terminated because they went for workers' compensation. Now, in that instance, they're most likely going to be compensated through workers' compensation, as well as they may get compensation through a general protections claim. Probation and short service exits where unfair dismissal is not available. Right now, guys, this is a very viable way that we can terminate people, right? Short service dismissal where the unfair dismissal is not available. However, that's only viable, guys, where there's no general protections risk, low general protections risk. I should mention there is never no general protections risk, right? Just low, medium, or high, I would say. So, for instance, let's say we want to terminate someone who's under 6 months probation. We're a large business, so we can do that. However, there might be some general protections risk, right? Well, until we've actually documented, that the termination isn't for that protected trait, right, whatever it may be, well, we're on the line for general protections risk, right? So where, a lot of people will think, oh, this is quite a low risk termination. Well, unfortunately, unless all avenues are sort of closed off, well, you might get a claim. So now, guys, let's look at unfair dismissal versus general protections. So as we've mentioned, 6 or 12 months minimum service is for unfair dismissal, whereas general protections has no minimum service period whatsoever, right? Somebody could be working for you for 2 days and then copy with a general protections claim. Now, for unfair dismissal, the high income threshold applies to award-free staff, right? So where an award does not cover an employee, maybe because they don't have classification under that award, it doesn't fit, for instance, or maybe they're remunerated a lot higher than what the award actually states, and they're maybe a manager. Well, the high income threshold will apply to those award-free staff, right? If they're above 190,000, right, etc. Well, they can't claim for unfair dismissal, right? But the main thing here, guys, is that they have to be above that, not covered by an award, right? There are times where an employee who is above the high income threshold can be covered by an award, but it's important to understand that, hey, this is a very case-by-case basis, and you're going to want an advisor to have a look at it. Now, with general protections, there is no income threshold, right? So what this means, guys, is that even your executives, right, at 250,000 plus, etc., they can make general protections claims. With unfair dismissal, the question is whether it was harsh, unjust, or unreasonable, right? This is what we're looking at. But when it comes to general protections, the question is why you made that decision, and was it as a result of adverse action against one of those protected rights or traits? When you're looking at unfair dismissal, the compensation, as we said, is capped at $95,050 or 26 weeks' pay. But for general protections, it's no compensation cap, right? Plus penalties against the business and individuals. So what this means essentially is that you're not only compensating the employee, but you're also paying fines to the ombudsman, right? Now, those contraventions can go anywhere up to 90,000, right? It does depend on how many times you contravene the same issue, but essentially, it's a lot of money, right? Now, when you're looking at unfair dismissal, this is arbitrated by the Fair Work Commission, whereas general protections is conciliated at the Commission, then court, unless both sides actually agree to arbitrate. So summary dismissal and underpayment. So some of you might be asking, what is summary dismissal? Look, this is the quickest way to turn a conduct issue into a pay claim, I would say. So now, guys, summary dismissal is where somebody has been terminated as a result of serious misconduct and they haven't been paid their notice, right? Now, look, this is something that's actually legally able to be done, right? However, the bar is high for the evidence burden, right? So what I'm talking about here, guys, is that when we allege serious misconduct, right, we're looking at the balance of probabilities, right? And where that balance of probabilities, is, I guess, harder to sway is where it's serious misconduct, where it meets one of the regulations, for instance. We don't want to use criminal words like theft, for instance, or anything like that, because it heightens the burden of proof to beyond reasonable doubt, which is something that we would use in court. So we want to make sure that we're actually a little bit lighter on what we're saying this is. They might have stolen something, right? But we don't want to sort of use criminal terminology for it. And the reason is because, like we said, the bar is high, right? Especially if we want to summarily dismiss an employee. Very, very okay for us to dismiss an employee for serious misconduct where the evidence probably wasn't fantastic and we didn't have enough for a summary dismissal. We can still do a serious misconduct dismissal, but we pay the notice, right? So now, what can meet the bar? So guys, theft, fraud, assault, right? Like we said, we don't want to use these terms, right? But these are the things that actually meet the bar. So willful conduct, inconsistent with continuing the employment, or with the contract as well. Serious and willful safety breaches that put others at risk, intoxication at work to the point of being unfit for duty, and refusing a lawful and or reasonable direction, right? Now, this is what meets the bar, but this is also what we're going to need evidence of, and really, really clear evidence of as well if we want to summarily dismiss. So now, what usually doesn't? So poor performance, right? However frustrating it may be, unfortunately, it's not. It just isn't evidence in terms of summary dismissal or serious misconduct. One heated exchange with no prior history might meet serious misconduct, but won't meet a serious dismissal, right? And one thing I do need to touch on, guys, right? There is no amount of warnings before a dismissal is safe, right? It's case by case every single time, right? You might have 3 warnings with somebody, right? But they've been there for 5 years, and for instance, the tenure sort of outweighs how many warnings they had. It might be on separate things, for instance. Really important that when they have the access to unfair dismissal or these general protections risk, that you have it assessed by somebody like myself. See, one heated exchange with no prior history can absolutely be serious misconduct and could result in a written warning, final written warning, etc. But if it was the first occasion, most likely not looking at a termination. Now, conduct you have tolerated before without addressing it, I think this one is a no-brainer, guys, because if we have conduct that we've tolerated before, done nothing about, well, what we have here is a precedent, right? So we've set a precedent that we don't do anything about this. And that's what's important here. Now, if we decide all of a sudden discipline for it, do something, a bit more formalized for it, well, the employee can argue that it was unfair, right? And in 9 times out of 10, they might be right. So what you want to do is reset the expectations, right? We can go through that in a bit. Another thing that doesn't sort of make the bar is allegations you have not put to the employee and tested, right? So as we said, guys, if we haven't put those allegations to the employee, we're asking for a response sort of on the spot, essentially. It's not really going to work out for us, right? As an example, let's say we do a disciplinary meeting, right? We invite the employee, we put the allegations in writing, maybe we forgot one, right? But we bring it up during the disciplinary meeting. The issue is that we can't actually use any of that to make a determination on whether or not they should get the warning, because they didn't have the evidence, right? They didn't have the allegation, they didn't have the notice, right? So we're unable to use it. Now, on this, guys, on serious misconduct, right, Regulation 1.07 defines what serious misconduct is under the Fair Work Act. And a conversation I do have a lot is, look, while you may think this is serious misconduct, what we're both going off is not what you think, not what I think is serious misconduct, but what Fair Work deems what serious misconduct is, right? And that's what's really important. When notice becomes an underpayment, right? So get the misconduct finding wrong and a pay claim follows. So look, notice becomes payable, for instance, where serious misconduct might be the only basis for withholding the notice, right? If the conduct falls short, notice was always owed, right? And this is what they're going to be looking at. So that is an underpayment from the termination date, right? And the issue with underpayment claims, guys, is that they have 7 years to claim for this, right? So this is something that can sort of follow you for a longer time, right? If not helped. Now, it is a separate breach, right? It is not something that is in the NES, right? It is something that would have to go through the court systems. So the notice shortfall breaches the national employment standards separately from the dismissal. It can run in court even if an unfair dismissal claim does fail, right? Accrued leave and any redundancy pay will sit in the same basket, right? If, for instance, wrong redundancy pay or accrued leave wasn't given. Now, guys, what's really important here on this piece, deductions, I want to make really clear that in 2026, nobody should be deducting from anybody's pay, right? And the reason for this is because it is such a massive underpayment risk, right? If it's not for the benefit of the employee. There's only one way you can deduct, right? Or lawfully deduct from an employee's pay. And that is if it is for their benefit, right? Now, a lot of the times people are deducting for fair reasons, for overpayment, right? For other reasons, right? Where that happens, guys, it's still considered underpayment, right? Because it's very hard to show that an overpayment deduction is for the benefit of the employee, right? And that's where these underpayment claims come into play. So instead of deducting for damage, shortfalls, unreturned property, guys, I think what we should really be moving to is repayment plans. And while there's not as much security with repayment plans, the issue falls to the same thing, right? At least we have no unfair dismissal risk, unfair underpayment risk, right? If we do need to take extra or further action, right, to recover the monies, it's the same as if, for instance, we would have to do that with any old person. We would have to go through court. And so that's what we should be doing moving forward, right? Unnecessary risk comes from deductions, I must say. So like we said, if it is for the benefit of the employee, deductions need written authority, like we said, again, and must benefit the employee. Now, withholding pay to force an outcome creates a second claim, right? This is something I have seen, unfortunately, but it does create other claims, right? For instance, general protections. And one big thing I should mention, guys, is that the stakes have changed, right? Now, the reason I'm so heavy on the last point is because, guys, wage theft is criminal now, right? So now what this means essentially is if you are seen to willfully withhold the pay of an employee, right, we're looking at up to 10 years worth of prison, right? Now that's not anything to sneeze at, of course. Now that's number one, and then we're looking at civil penalties up to $1 million, for instance, for a single contravention. So now those civil penalties per contravention have risen again on the 1st of July 2026, right? And like I said, guys, these contraventions compound, where they have seen that you've done this with multiple people, that's multiple fines, right? So honest mistakes, however, these are not criminal, right? Where we have absolutely made a mistake, we have not willfully underpaid an employee, we will not have criminal action taken against us, but they are still recoverable, right? So we will still have to pay the employee back. So now moving on to redundancy. So genuine or just a convenient label. So now look, there's 3 tests to, I guess, test that. Is it genuine redundancy or is it a label? So the main things here is that the job is no longer required by anyone, right? That's your main one. The second would be because of a real change in your operational requirements, right? Now, if that is the case, it's really important that you guys can show that, right? Something like a business case for redundancy, maybe showing, the downfall of the profits, for instance, in the last 6 months, last 7 months, whatever it may be. This is going to help you if you're questioned. So now, backfilling the role afterwards undoes the whole thing, right? Now, this is not to say you can't do that, right? So I have had clients who have had a genuine redundancy, a genuine real reason to make the role redundant, right? And then, for instance, 6 months later, the need really did rise, for instance, to hire somebody back in a similar role, right? Now, obviously, that's 6 months later, still very risky, right? But that's much further than the 21 days from when an employee can actually claim unfair dismissal, right? Now, for example, if you backfill the role right after making someone redundant, that is essentially high risk, right? If the employee does find out, obviously, could be an extenuating circumstance that a commissioner might view. Another test is that you consulted, right? So the awards are what what makes us have to consult, right? So they have provisions in them that are called, provisions to obviously consult for a major workplace change, right? Now, it tells us what it deems a major workplace change to be. That's loss of tenure and or job, right? Or major change to the workplace or job description, for instance, right? So that is redundancy. So the award, right, is actually what's making us consult with the employee, right? Where the employee is award free, we actually don't have to consult, but it's best practice, right? Now, of course, what happens if we don't consult? If they are an award free employee and we don't consult, we just move straight to the outcome. Look, that might be fine, right? However, best practice would be to document, did we speak about redeployment, right? Did we speak about, for instance, any other options that may have been viable to the employee? This is, again, more so a best practice thing, right? But again, something that I would recommend. So as we said, consulted as the agreement requires, water agreement. We want to notify, share information, invite ideas, and genuinely consider them during the actual consultation meeting, right? So notification obviously would happen before that. The information should be shared before, obviously, the meeting as well in the actual invite. And of course, we want to invite them to come up with any ideas, right, that they might have to avoid the redundancy. This happens sometimes, right? We do see employees that might elect to either just go redundant, or, for instance, they might come up with another plan like, hey, look, I'm happy to go on an extended period of leave without pay, or some other way that they might look at. But the main thing here, guys, is to genuinely consider it, right? Now, consult before the decision is locked in, not after. Now, I know we've probably got some people saying, well, what if it's just one role and we know? What if it is a predetermined outcome? We can't really sort of get around it. Look, guys, unfortunately, the way that we do the process, right, it's really important that at no point can this be seen as a predetermined outcome, even if they are the only one, and we don't really have any redeployment options, right? We're exploring opportunities right till the end, right? So, of course, consult before the decision is locked in, not after. Final test, guys. Redeployment, was it reasonable or wasn't it, right? And then the big question, why? Why wasn't it reasonable, right? Now, we can't decide on behalf of an employee who might be able to do another role whether or not they were reasonable for that role, right? Or if it wasn't reasonable to put them into that role. Now, look, we can't do that where there is a bit of reasonability that we could have offered it to them. Maybe they have the skills, right? Maybe they have, maybe they absolutely can do it, but it's a lot cheaper a role, and we just didn't think they would go for it. Well, that's on them to make, right? And it's really important that we still offer it anyways, right? Regardless of whether or not we think they're going to take it or not. Where we don't offer that redeployment and there is viable options that they could have done, well, if they go through unfair dismissal, there's a possibility for redeployment back into the role. When we look at this as well, we want to look across associated entities, right? And associated entities are, of course, your sister companies, right, run by the same director. Now, what's really important here, guys, is that if the associated entity is run by the same board, same director, right, you're most likely looking at an associated entity, right? I'm not going to go into a lot of detail about associated entities because there is quite a bit to it. Feel free to obviously have a conversation with me at some point on that. However, right, 9 times out of 10, same board, same director, it's an associated entity, right? So we have to look across those associated entities on whether or not there is a redeployment option. If there is, it's absolutely something we should be looking at, something we should offer to the employee. So since Helensburgh, Cole versus Bartley, the commission can actually ask whether you could have insourced contractor work, right? So for instance, whether the redeployment was not reasonable, could you have insourced a contractor essentially to have done that? So now moving on to something a bit more specific to your trades industries, right? So now, guys, what's something that I find almost every second day, I have this conversation with somebody in the trades sector where they are unaware of a industry-specific redundancy scheme, right? So guys, for these awards, there's different rules onto whether or not it's a redundancy or not, right? For building construction, I'm not going to go into every single one, but for building construction itself, this is an award that basically states where any termination besides a termination for serious misconduct is a redundancy. This means that redundancy pay on top of notice, on top of entitlements, all of it is payable when an employee is terminated, right? And this is even before 12 months, right? The issue, again, with these industry-specific redundancy schemes, guys, is that these apply to small businesses of less than 15 employees. This means that regardless of how small we are, we could have 1, we could have 2 employees, but the industry-specific scheme might still apply to us, unfortunately. And again, building construction is one of those where it does apply to even small businesses. And unfortunately, almost every termination, even resignation, is a redundancy. So it's really important, guys, to check your awards, right? Where you are under one of these trades awards, building construction, plumbing, black coal, mobile crane, joinery and building trades, right? You guys have industry-specific redundancy schemes, right? Where you guys are not aware of this, immediately you have underpayment risk, right? Because this is the award that applies, unfortunately, and if we haven't been paying redundancy pay, well, we're looking at a lot of people who may need that back pay, right? So now what are the changes here, right? So the NES redundancy provisions, once we have these that apply to us, if we are under one of these awards, the NES redundancy provisions are displaced entirely. This completely overrides them, right? The reason being is because the employee is better off overall. Now, on the building and plumbing awards, like we said, redundancy means employment ending for any reason. Now, that can include an employee resigning after 12 months of service, right? And like I said, small business exemption does not save you. So the contributions to an approved fund, such as Increlink, or ACIRT, however, can offset it, right? So now, if you are in trades, and that makes sense to you, obviously, this is something that you can use, right? Moving to paying entitlements as a whole. So this is the part that generates claims long after the conversation is actually over. So what actually goes into final pay? Well, we want to work through it line by line before we actually set the end date. So we want wages for all the time worked up to and including the last day, accrued annual leave, plus loading where it would have been paid. You need to check your awards for this. Payment in lieu of notice where they are not working it out. Redundancy pay under the National Employment Standards or the industry-specific scheme if one does apply. Long service leave under the relevant state or territory act. Superannuation on all eligible amounts. And then finally, personal and carers leave is actually not paid out, guys. So now, just going back to accrued annual leave, loading, all these different things, guys, and I guess payment in lieu of notice. So one thing that I saw in a bit of case law was that an employee was paid in lieu of their notice, right? They were paid their entitlements. However, when it came to their notice, right, the employee actually wanted to work their notice. Right now, a lot of the time when it comes to a termination, it's generally on the employee to decide whether or not the employee works out the notice or not. Now, that historically has been the case. The issue here is that the employee argued that because he wasn't allowed to work out his notice, he was actually stopped from accruing annual leave across those days, right? And unfortunately, he won that claim, right? So now this is an important thing to sort of look at. Okay, if we are paying in lieu of notice, the most risk-adverse thing there to do to avoid an underpayment claim of some type, right, is to work out what the accrued annual leave would have been if he did work that week or that 2 weeks notice, right? And apply that to the final payment, right? When does it have to be paid, right? So this is a bit of a loaded question because it changes. It changes depending on what award you're under, right? I mean, if you're not under the award, it's generally the same, right? But most modern awards will require final pay within 7 days of the last day, right, of the final termination date. Now, that's not to say, guys, that it makes it easy. It can absolutely tell you how it needs to be paid in terms of electronic payment, or some awards actually say it needs to be paid in cash, right? So you're going to want to look at all these things as well. Now, the courts have actually gone a little bit further. Notice, leave, and redundancy fall due on the termination date itself, right? These are entitlements, for instance. So in the Jewel versus Magnum case, paying 11 days late was a breach even though it was paid in full, right? Now, that's obviously with an award saying that they have 7 days. Now, where an employee is award-free, right, that's where everything needs to be paid on the final date, right, in terms of entitlements, that is, right? Wages, right, well, the Act actually says that an employee needs to be paid at least monthly, right? So in that case, the entitlements would be paid on the date of termination, but the wages don't have to be, right, if that makes sense. Now, look, in all honesty though, guys, rolling it into your next ordinary pay run is the most common and most expensive mistake, right? What we want to do is align the termination date with our pay cycle or run an off-cycle payment, yeah? Now, late payment is an underpayment, right? Each contravention carries its own penalty, and as we said, they compound, right? One on top of the other. So now, before you confirm the decision, guys, a short check, right, that heads off most of the claims. Can we check the reason? And can we state it, right? Can we explain it in one sentence and evidence it? Would it still hold, for instance, if they had ever raised a complaint or taken leave? Conduct, capacity, or redundancy, does the paperwork match? Let's check the process as well. Do we have the allegations in writing? Do we have a real chance to respond? A support person that was offered or not denied? The decision maker, did they consider the response before deciding, or did they give them the written warning right after the meeting? Notes, dates, outcomes all need to be on file and written at the time. Next one would be to check the money. Award and classification must be confirmed, right? The notice period must be correct. Redundancy must be checked against the national employment standards and or the award, because that's going to be where the industry scheme is. And then finally, the final pay modeled before the date is actually set. Okay. And then finally, guys, check the timing, right? Notice, leave, and redundancy paid on the termination date must be, right? Separation documents issued, records kept for 7 years, right? As we've noticed, 7 years for an underpayment claim, 7 years for us to keep records, right? That's the reason why. Diarize the 21-day window and act fast if anything lands. Let's get to questions. We've got a bit of time. Can we see if anybody's got any questions? Okay, let's answer this one live. So are casuals that are engaged regularly entitled to make an unfair dismissal claim? Yes, they are. It does depend. It is a case-by-case basis, right? I would tell you to get a bit of advice on it, right? Look, what does regular and systematic mean, right? That's what we're looking at. We're looking at, can this employee be considered, actually, sorry, we're not really looking at that anymore. Since the changes to casual employment, we're looking at, is there an ongoing expectation of work, right? If there is, and they've exceeded the 6 months or the 12 months, yes, yeah, they're most likely able to make a claim. Does the 6 months of continuous service include unpaid leave? No, right? So you can extend the probation of by the amount of unpaid leave, right? This happens quite a lot, guys. Any unpaid leave, right, where an employee's out of sick leave, where they're out of leave entirely, right, and they're only using leave without pay, this does not actually apply to the continuous service period. So if we have a special training clause in someone's contract wherein if someone leaves before the training assignment is completed, can you recover the training cost? Yes, but guys, it's important on how you get that cost back, right? So look, if you're terminating somebody, kind of hard to get it back, right? Because why would they, right? I mean, at the end of the day, they most likely might know that they'd have to come after you through the court systems to get it, right? So look, I mean, a lot of the times it is hard, right? I'm not going to say it's not. Deducting it is a worst case scenario, though, right? So look, if we did have it, we absolutely can put out a recovery plan, right, where they pay us from their account, right? That's the workaround here, right? As long as it's not deducted, it doesn't really matter, right? You could get it in a repayment plan. You could get it through some other way, right? The main thing is that we're not deducting it. So now, where would an employee claim underpayment, right? Okay, so where they would claim underpayment is, look, they would generally speaking, a lot of the time they would go to an employee, go to Fair Work Ombudsman, right? What they're going to get is a little bit of advice, right, from the Ombudsman themselves. What they're going to do is they're going to give you a letter of demand, right? So the letter of demand, of course, usually will give you about 7 days to actually get the repayment sorted. If that's not done, they're going to take you through court, right? So what you're looking at, guys, is, the claim for underpayment is generally done through the court system. I've got a question, 7 working days, just 2 questions. If you want to ask that question again with just a tad more context, I can absolutely answer that. Are we talking 7 working days for final payment? Yes, we are, right? 7 working days for final payment. That's correct. So, you're looking at, for instance, your 5 Monday to Friday, right? Monday, Tuesday, right? That's going to be your 7 working days. And most awards do actually allow for that as well. It's quite rare that I find that an award will say, oh no, it needs to be done exactly on the termination date. The 6 months trial period should be in the contract. Yes, doesn't matter though, right? I guess, look, the main thing, Fernando, would be probation doesn't really matter even if we did put it in the contract, right? Because the minimum employment period is still going to apply, right? The reason a lot of employers put probation in their contract, right, is because it's a management tool, right? It's still a tool for us to be able to say, look, you haven't passed your probation due to X reason, right? And that is enforceable while they're under that minimum employment period, right? But yes, to answer your question sort of lightly, yeah, the 6 months trial period should be in the contract. But again, not enforceable if they've passed that minimum period. So we pay support workers on rostered and contracted hours in final pay. I'm assuming they're asking, do we pay support workers on rostered and contracted hours in the final pay? That would be yes, right? Look, I would want to look at that a little bit deeper because the SHADS award is a bit of a beast. But for the most part, yes, right? Specifically if that was rostered and contracted, right? I mean, look, contracted hours, right? For instance, if we're talking about an employee who's part-time, as the employer, it's on us to give them those hours, for instance, where they haven't made those hours up and it's not their fault. Essentially, we would have to pay that anyways. So what if the award doesn't state final payment within a time frame? Very rare. I don't think I've actually ever seen that before, to be honest. However, it would fall back to the NES, right? So where terms are a little bit, or where terms, I guess, don't exist in an award, you're falling back to the previous piece of legislation, right? So I guess the piece underneath it, right? I guess your sort of safety net, if anything, right? So when you're looking at the award, right? If you're looking at notice and termination provisions, it doesn't give you a time frame. I mean, it's going to fall back to the award, back to the National Employment Standards, which means that you would have to pay the entitlements on the day, right? But the wages would have to be at least in the month. You said there needed to be a trend/investigation for serious misconduct. What about worse than that? And you involve the authorities, gross misconduct. So same thing, really. I mean, it does depend. I mean, gross misconduct and serious misconduct, I think, get mistaken for each other quite a lot. They're actually essentially the same thing. But look, where it is something that's involved with the police, I mean, it's no longer. I mean, it depends on what happened, right? But there's an aspect of, is this your investigation to actually hold, right? If the police are involved, right? Look, depending on how involved your business is, again, that might change. But I mean, if that happens, right, a lot of the time it actually means the contract is repudiated, right? And what that means is, or actually an easier term, frustrated, right? If you guys have ever heard of frustration of contract, incarceration is one of those things, right? So for instance, where the authorities have gotten involved, let's say the employee's been they've been arrested, right? And we won't be able to, for instance, get a reply or response to them from a long time. Well, you're looking at a frustration of contract. We might not even have to go through, a serious misconduct termination, right? It would depend, though, right? It's a bit of a loaded question, that one. Okay, what penalties could an employer face if they don't pay your entitlements on the day? Which court could this be enforced in? So this would be through the, I believe it's small claims courts. However, what penalties could an employer face if they don't pay the entitlements on the day? So there are contraventions that you guys can go through, right? Now, look, I don't want to, I didn't sort of name every one of them because I don't want to scare anybody. They tend to sort of start at around 90,000 for an individual, right? And like I said, guys, these can compound, right? It does depend on what you've done, whether it's a contravention. For instance, look, if we're looking at entitlements, this is contravention against the award, right? As well as possible underpayment. So look, it does depend on the way in which I guess in terms of what claim has come to you, right? Because look, entitlements not being paid again is also a general protections issue. It's essentially two things, right? So the dependent on the type of claim that you've gotten depends on what fines you're going to get, right? What compensation you're going to pay, if that makes sense. The next one, so Trinity is asked, when does final payment need to happen under the SHADS award? I'm just going to quickly share my screen. I'm going to the Fair Work Ombudsman's website. Now, what you can see, guys, here is a list of awards. I'm going all the way down to the Social Community and Home Care and Disability Services Award, right? One of my favorite awards. To look on when payment must be made, right? So termination of employment, right, is generally where we want to go. So termination of employment, notice of termination, that'll tell you basically everything we need to know about when it needs to be paid, what the notice is, right? Now, as you go down, right, payment is where you actually want to look, or payment of wages. There we go. So 24, this will tell you guys. 24.2, payment on termination of employment. So as we can see here, guys, the employer must pay an employee no later than 7 days, and after which employment terminates, right? So as usual, we'll find that's going to be the case, right? It's going to be 7 days after the date on which the employee has been terminated. Look, guys, unless there's any more questions, I think that's time. Hopefully you enjoyed the webinar. I do apologize about some little technical issues and if you heard the beeping in the background at that point. But hope you have a lovely rest of your day and enjoy. Thank you.